Audio Jungle.
So, I want us to pick up the discussion where we left off. First of all, this is the second time recording this because we lost the audio. No, we had bad audio.
Yeah.
But at least today we're back. And yeah, watu wamekuulizia bana. Watu wako like, okay, si wamekuulizia, wameichia lawyer random. Uzuri wende huko. Watu wekata.
Mimi ndo niko. Yeah.
Shut.
Continue.
So, the discussion was about
Intellectual property.
intellectual property in Kenya. And this is coming from a point where while doing DIRA and everything, I started learning about it. And then I consulted you and then we figured, there's a lot to it here. And especially trademarks, copyrights, utility models, patents, na vitu zingine, which I've had. Now, I've been talking about this on the channel, on my social media. Ungedhani mimi ni lawyer. So today I just thought, let me bring an expert in these things. So let's start.
Okay.
What is intellectual property?
Well, it's actually in the name.
Uh-huh.
So it's property, something to be owned,
Intangible.
but it is intangible.
Okay.
And most of the time, it's not just intangibility like air. It's something that has come from
Okay.
intellectual. Yeah.
Why is it important?
So you see, it's because it is something from an intellectual place. Then it's yours. If you own something, then it means you have rights over it. If you have rights over something, then it means someone else has been secluded from it. So then we have to talk about whether you can share those rights, like licensing, all those things, or how you can prevent any other person from using it for the sake of being the only person who has such a thing. So it's important for businesses to now give themselves an edge like that, in that way, or to make money out of it.
Businesses and individuals.
Yes.
All right. So in Kenya, I've seen that it's intellectual property is under the Kenya Industrial Properties Act. We're talking about Kenyan law. And how, yes, some of these laws were made in 2001, and I wonder, with so much change that has happened, do they still adequately protect you?
Yes and no. Most of the time, okay. The thing about our legal system is that it waits for a reason.
It's
to
reactionary.
update. Yes. So now, for example, with how AI is coming up, we have an AI policy, and there's a possibility that now the Industrial Property Act might be amended or revised to encompass now AI inventions.
But even then, the small protection that it gives, I don't think it's small. First of all,
it
just take
covers
it. Take it.
Quite generally.
Yeah, cover it. Okay.
Yeah.
So we've talked about Properties Act, patents, and utility models. We've talked about copyrights, trademarks. What are these things? What are these?
Okay.
Define them, and when do you use them?
Okay. Let's start with what seems the biggest. Let's start with patents. Then we talk about utility models because they are related.
Yeah.
So patents basically protect inventions, and they have to be very new, and they have to be industrially applicable.
Okay.
And then, so the difference between a patent and a utility model is the newness, so to speak. If, for example, I invent this ring, for it to be protected, you have to show that no one else has ever invented this particular ring.
Okay.
So it does not exist, basically.
It's something that doesn't exist.
Yeah, so it's new. Yeah. But if I want to just maybe add some design on top here, then I will use an industrial utility model. Because basically what it protects is the additional invention to a pre-existing thing.
Product or process.
Yes.
So
whatever
a
you have
utility
added
model is
something,
a small patent.
basically.
Easier to file.
Actually, yes. duration wise, and also the examination that they usually do before they approve.
What do you mean by duration?
Okay, so there's two aspects to look at it. How long it will last, how long if
you're protected,
yes, but also how long the application period is.
Okay.
Because they will do a preliminary examination and then a substantive examination. And then if it passes, then there's a publication and advertisement, and then you get the certificate.
Okay.
So this duration for all this process is shorter for a utility model because it's not that new. For a patent, it has to be very, very thorough to make sure it does not exist.
And do they just check the Kenyan markets across the world?
It depends on where you're protecting it. If you're protecting it in Kenya, then they will check
just Kenya. So you can come, you can see an idea huko nje, then you come and protect it in Kenya.
In Kenya, yes. But you also have to make sure that person huko nje
did protect it across the whole world.
Yes.
Oh, and then how would you? Maybe it's a conversation for like hapo mbele, yeah. But yeah, in terms of, let's say you wanted now to file in Africa, or you went to file across the world. So you have to put a pin on that.
Yeah. Also, the institute that does that here in Kenya is called KIPI, Kenya Industrial Property Institute.
Okay.
Yes.
Established under
the Act.
The Act. Yes. Yeah. Nimesoma hii Act.
No. Very informed clients.
So utakata bei sasa.
Move on.
Hadi na kufanyia nini?
No, just next.
Yeah. But anyway, so you've said the rules for UM are stringent, and for a patent are more stringent than
a utility model.
So how long is your idea or invention protected?
For a utility model, it's 10 years, and for a patent, 20 years.
Renewable?
Then, yes and no. You renew for the 20.
Oh, you renew annually?
Yes.
For those. But once 20 years has passed, it moves to.
You can now convert it to a UM or a
public domain.
Or the other way around.
Really?
No.
What do you mean convert it to a UM? Let's say I invented something in 2004. It's to 2025. Imeisha last year.
You can't. If it's a utility model, Nivo, after 10 years.
Wacha wengine enjoy.
Yeah. But then the thing is, you can convert it to a patent. The rules will remain the same.
Yeah. So you'll start off a new period.
Yes.
If it's accepted.
Yes.
Very nice. Very nice. And with the Industrial Properties Act, those are the only two things that exist.
For the Act, there's also industrial design.
Yeah.
So basically, it protects what you see. Like, for example, the Coca-Cola bottle. See, that's just how it. That's how it looks. That's how the bottle looks. So Coca-Cola has protected that specific look.
Is that a patent or a copyright?
No, it's an industrial design. Yes.
Oh.
Yes.
I'm in love with the shape of you. Yes. Very nice. All right. So here I am, kijana barubaru. I've come up with another Coca-Cola bottle. Nimefurahi sana. Yeah. Hiyo ita utapenda. Ita hapo utagonga mzee. Yeah. Now, where do I start? And how much does it cost?
Okay. Where you start is first getting someone who understands this. Anyway, so
shameless.
So, you have to put it in writing first. The Industrial Property Act has broken it down.
Yeah.
So you put it in writing. You say what you're requesting. You give the details of your invention.
Yeah.
You say what you're claiming to protect in that invention.
Yeah.
Because there's a case. Some individual was claiming the back end of, is it Fuliza, the back end of
Oh,
Fuliza, is his invention.
Yeah.
But then the court was looking at what exactly, when you submitted your things to KIPI, what did you say you want to own?
Yeah.
So this individual was protecting it based on a different, like you see, an app can be based on, I think, software, or it could also be AI.
Yeah.
So if you say your app is based on AI, then if someone comes with a software,
Oh, I get you.
Yes, those are two different entities. So what you can now go to court and say is, this person, their thing looks like mine, and I protected it first, so yake ikansoliwe, yangu ibaki. Does that make sense?
I get you.
Yes, but anyway, so your question was, where do you start?
Yeah.
So you put all those things in writing. You
and the writing has to be done
the actual way how the law has said.
No, even for you to cover, you know how you said app, AI. So you need an intellectual property lawyer who is familiar with.
Yes.
All right.
So you put everything in writing in the specific forms for the organization, for the institute, and then now he submitted for the first preliminary examination. That one is, depending on if it's a patent or utility model, the range is at most 4K for the first exam.
Yeah.
And then if it passes, it goes to the substantive examination, which is 3K.
Okay.
Or thereabout. And then after those two have passed, then it goes to the publication stage. So this publication is basically, they've listed all the inventors and then they've posted it on their website. So that if someone has claims that hapa kuna something that is mine, they can make an objection.
How long do they have?
2 months.
2 months.
2 months. Yeah, so they can make an objection. There's a tribunal that deals with those issues. So then it handles who gets the priority, and then after the 2 months period, which you also pay for, which is 3 to 4K as well. And then now, after the 2 months, if there's no objection or the objection has been dealt with, then we get to the certification stage. Yeah. And then now you pay for the certification, which is again 3 to 4K.
Yeah. Oh, something I also learned while dealing with you.
I know. You're like, okay.
I'm trying my best.
Okay.
But it's the date of filing.
Yeah.
The date of filing is important.
Yes, because you see, if an issue comes up, what is the basis for either the court or the tribunal to deal with? First, it's priority.
Yeah.
So the date of filing gives you the priority.
So that means you need, if we come up with the same idea, ama nikusikize, hiyo nimependa. Me, it's Friday, you're going out. And you say you'll go on Monday. I mean,
ulienda KIPI Friday. Itabidi wekupe. It's yours.
Unless it can go to tribunal, and you don't need. Do you need to prove like I'm the one?
So that's
just the person who files.
How will you prove
the person who files is?
Yes, because it's however kuna your proof. Like if we both come and say this thing is mine, we have to show. We need something to show for it.
Yeah.
So the date of filing is what you show
the first person.
Yeah. Utaenda tu sema hizo ni stories za jaba, so huyu ndio akona proof.
The same way we've said, we're somewhere discussing on a Friday and we're talking and I make the idea public. Now, it's been discussed, nimeenda interview somewhere. We get, I'm yapping about it everywhere. Mimi mnoma, mimi creativity mbaya. How does that now work? When you've already, the idea is it's already out there, and it's not filed. Like I've talked about it publicly.
And it's not filed?
It's not
someone
filed.
Else can
I show that I talked about it? Let's say we talked about it on Friday, on Thursday. You filed on Friday, and on Monday, mimi nienda kufile niambie Iza. Can I say, on Thursday I talked about it?
That's tricky. Like you can go and say that, but kuna kwanga na value of your evidence.
Oh, okay.
if someone has already filed it before you, their evidence is stronger than someone who will say, I was on the news talking about it. Like, how do you know?
Yeah. Okay, let's say no one files for it and I've been talking about it.
Okay.
Is there a point where I lose? After a while, in public knowledge, bana.
Yeah, 12. But then, okay, it depends on the public domain. It depends on specifically what you're saying. You can talk about something in general, and then that we assume you're something for everyone. If it's a specific thing that looks like an actual invention that meets the the criteria, then it's 12 months.
Okay.
Also, I think it's my phone. Also, it's a thing with if you protect it in Kenya, and then there's also a lapse of over 12 months.
12 months.
After, you cannot now go.
If you protect it in Kenya,
Africa.
If you protect it in Kenya, if you go public about it.
Pardon?
If I protect it in Kenya, after 12 months, I can't go protect it outside.
Kama, hii time yetu nilikuwa nafanya.
Oh.
Yes, sasa si imefika ile public domain yenye tulikuwa tunasema.
Okay.
Yeah.
Well, all right. So if I make it public, I have 12 months to file.
Sort your house and go
file. And that's filed before anyone else. First to file wins. All right. I love that you've given us the cost. Is there any more you want to add on that, especially on the filing process? Can I do it myself? To just deal with the lawyer.
Like you can. I mean, you can, but then you need this information.
Yeah.
Which, if you're not a lawyer, and also you've not. General lawyers might not have the details of how it works.
Oh, you need an IP lawyer.
Yeah. Someone who has also dealt with KIPI people, someone, because we're in Kenya, someone who knows someone in KIPI. It makes it easier. Not that it won't work.
Yeah.
It's just, utaishi hapo.
Yeah, you don't have time.
Yeah, exactly. Timelines are important.
Well, so let's say I came up with a song.
Okay.
How is that protected?
So a song is a creative thing. It's not considered an invention. It's considered
but are there aspects of music that are considered patents? Like how Ed Sheeran, there's a time but I think that's copyright. Right?
Yeah.
It's copyright?
Yeah, it's copyright.
Okay.
Because it's considered a creative work.
Okay.
That is expressed
Okay.
through music.